like to ask all of our panelists for their key takeaways or their final thoughts. Josh, you led us off this afternoon. Perhaps you want to be the first to give us some of your key takeaways.
Sure, and thanks again to the moderator and to everybody who dialed in, and to the other panelists. I actually, the last thing that Zeke just said, it reminded me that I think a lot of times these issues where, we have these doctrinal questions of whether or not a court can consider, a particular issue, whether it's the issue of loss causation or the presumption of reliance, kind of at the class certification stage. We can get too maybe focused on that and ignoring that these same arguments can be made in other places as well. And a lot of times, especially when it comes to issues of damages, which was the focus of my presentation, I think you have issues of standing that can be asserted at the motion to dismiss stage if there are some class members who do not suffer any damages. You can also potentially assert those, at the summary judgment stage as well. So I think, a takeaway from here is kind of from intertwining all three of these presentations. I think a lot of this is figuring out the right time to make these arguments, and it may be a matter of making them multiple times throughout the life cycle of a litigation.
Thank you so much, Josh. Gary, we then heard from you. Perhaps you want to give us a few of your final thoughts.
Sure. Focusing on the arbitration issue that I was talking about, I would say I guess the takeaway would be the Supreme Court has been very receptive to compelling arbitration and to class action waivers, but there's still more ground to be covered on that issue, with challenges to whether there's actually mutual consent, whether a contract has been formed, whether there's been sufficient conspicuous notice. So, these other issues are also litigated in the context of motions to compel. But, the Lamps Plus case seems to indicate that the court is not going to waver from its reception to class action waivers.
Thank you so much, Zeke. We heard from you last, but by no means least. Perhaps you want to close us out with a few of your final thoughts.
Sure, thank you. And yeah, I would just echo what the other panel said, and just thanks everybody for calling in, and the moderator and the other panelists. So I mentioned this a second ago. I think in terms of the BMS and the class in the class action context, really it remains to be seen, and we're in very early days there. And even by the end of this calendar year, things may look somewhat different than they do today. In terms of the class certification and reliance in the securities class action context, I think that the takeaway kind of from the cases we discussed is really for defendants in opposing class certification, a lot of this comes down to the ability to rebut the basic presumption of reliance, and there's certainly been some constraints placed on that by the Supreme Court declaring some very similar concepts are off limits at the class certification stage. But I think it really is worth emphasizing that for defendants, they need to tailor their arguments to address very precisely the impact of the price impact issue, rather than issues of materiality or loss causation, and that will help kind of position themselves as best they can for courts to look on the arguments being put forth as the proper arguments in the class certification context.